somewhat. Attorney General Alan Wilson is here, of course. Most of you are aware of what we talked about in relation to the Fremantle Preston case that was appealed in front of the Supreme Court. Now, I've already played a little bit of this for the benefit of Mr. Wilson. We'll try to do it again.
$1 million+ for a severance contract for Mr. Preston, so-called severance. It was a means of his buddies buying him off because they were afraid the next crowd on council was going to terminate him. This wasn't any kind of thing that kind of came up all of a sudden and was an emergency, except to the extent that Mr. Preston considered it an emergency to get his golden parachute taken care of.
One or the other.
Nothing told to the public about that matter being brought. Obviously, in the meeting that much discussion has been had by a majority of the council members among themselves about this issue, and yet the public not notified on. This wasn't an emergency. $1 million+ for a severance contract for Mr. Preston, so-called severance. It was a means of his buddies buying him off because they were afraid the next crowd on council was going to terminate him.
Okay, that's just excerpts from the hearing. It took about 30 minutes, overall. And Gene Toll was very vocal, about that, and all the others were complicit with her and what she said. It's been remanded back to the lower court. So I don't know if it's been filed yet or not. It's a summary judgment. I think that's what the attorney representing Mr. Fremantle, who is here, by the way, is going to do. I really see no way they can do anything but say, yeah, it's a violation for you. Yeah. So what you going to do? End up back in the lab and Gene already told you what you going to do. I mean, it doesn't take a rocket scientist to figure that out. Now, of course, the thing in question here that everybody has is basically what's up with the grand jury. Now, when you and I talked originally, and of course, I think you'll acknowledge the fact that I was not happy myself. When we chatted for a good half hour or so, and I was trying to contain myself as much as I could, but noting that, then of course reading it again and again and again, and reading it to the audience as well, many of them that are here now are also aware of all this and very much concerned about what's going on and what did go on. And one of the questions was, is this the end? And all I can say is, I hope not. I hope not. And reading that again, what I got out of it was basically, they only looked at the illegality of the buyout itself. What did Mr. Preston do anything wrong? Illegal. Am I right?
You want me to start right now and talk about this after we just merge into it?
Well, just merge in. You're the man.
All right, well.
You're the man. But I'm just telling you, consider this informal. I mean, you're not in front of Gene Toll or anybody else. You're just in front of constituents here that are concerned. And
what I'm going to do is I'm going to talk about a couple of issues. Can everyone hear me?
no, not yet, because I got you turned down.
All right.
We're good. Okay. It's so sensitive.
Can everybody hear me? Can y'all hear me? Everybody here on the back, on this side, on this side? Y'all can? They can hear.
You can hear? Everything's fine?
Can we give me the mic?
That might be better to do that. Just turn that off and leave it attached. Then we'll see if we can work it out later. Maybe I can.
Give me over, Ray.
How about that?
All right. How about now? Everybody can hear me? We're going better? Okay. First off, Mr. Driver, thank you for allowing me to come up here. You and I spoke probably about 4 or 5 weeks ago, and you wanted me to come up to Anderson, and I told you I would. Before I get into some of the issues we're going to talk about today, I want to do a couple of things. I want to give you a little bit of, I want to introduce two people that came up with me today. Adam Piper, who works in my office in the executive section of our office. We have Curtis Pauly, who's Assistant Deputy Attorney General in our prosecution division, works down there with the grand jury. Real quick, the month of June was somewhat busy for me. My wife and I took our first vacation probably in a year for about Memorial Day weekend. I came back, and then I left to go to Colorado Springs, Colorado for the Republican Attorney General's Association in the anticipation of the Obamacare ruling. Came back from that, had 2 days of drill, then left 2 days of drill, went to Charlottesville, Virginia for a week for annual training with the National Guard, came back, packed up my entire house, then flew to Anchorage, Alaska for the National Attorneys General Association, and then flew back from Anchorage, Alaska, back to my house, to move out of my house, my wife and my 2 toddlers. The week that we had the Obamacare ruling, I was living out of boxes in my parents' house. I'm 39 years old, and I'm living with my mom and dad, so you can imagine how that felt going through all of that. And then, of course, on the 4th of July weekend, we were able to move into a new home, and so when Mr. Driver and I spoke in early June, I said, Rick, I will come up here because my job is to work for all of you. You're my boss. I said, just be patient with me because I'm kind of busy in the month of June. So I wanted to give you some context on as to why I haven't been able to get up here in the last couple of weeks. But my first free weekend in probably over a month, and I'm up here this morning. Sorry for the delay. Anytime you look to find a shortcut to get somewhere, it ends up costing you more time, and that happened to us. But I apologize. Thank you for your patience, and let's just go on into it. Can y'all hear me? Okay. First, let's talk about immigration. And we'll talk about immigration, we'll talk about healthcare, we'll talk about voter ID, and we'll talk about grand jury processes, and we'll open up for questions. Does that cover about everything everyone's interested in? Yeah. Okay, that's what we'll do. Gun control. She wants to talk about, I'll let you ask a question about that during the Q&A time. Okay, first off, immigration. As y'all know, South Carolina in 2009 passed the immigration enforcement law. That was the Justice Department got in our way, basically said, you can't do that, you're preempted by federal law. We said, oh yes we can. We filed a suit, well actually they filed a suit against us in Charleston. Now this is something that's interesting. They filed a lawsuit against me and Governor Haley in our official capacities as Attorney General and Governor, trying to enjoin us from implementing this law. First off, I'm not the implementer, I'm the enforcer. I didn't pass it, but they sued the governor and me in Charleston District Court. Now, they didn't get us in Columbia, they got us in Charleston. So we went down to Charleston and we argued, and a federal district judge basically said our Arizona law was preempted by federal law and we could not implement and give law enforcement the ability to enforce immigration laws that mirror exactly what the feds are already doing. So we were going to go forward and litigate this against the Department of Justice, but instead of getting too far out in front of it, we knew that Arizona was litigating nearly an identical law, and some components of it were identical already. They were already going to the Supreme Court. So we kind of sat back because it costs money to litigate. And if Arizona's already fighting this war, let's let them fight it, let's see what happens. I actually was up there, I was up in the U.S. Supreme Court observing Arizona's arguments a couple of months ago, and the Supreme Court came back, and as y'all know, they ruled parts of it were preempted, parts of it that they were going to allow to go into effect. A lot of people said that the bulk of it was against South Carolina, against Arizona, in favor of the administration. I'm here to tell you today, that's not exactly accurate. There were three major components of our law that overlapped with Arizona's law. The Supreme Court upheld one component of Arizona's law, which means one component of our law is going to be upheld, and I'll tell you what that is in a second. One component was struck down, and one component wasn't even discussed. The component of our law that was upheld was the most important component of our law. It was the part that I thought was the most pro-law enforcement. It was the part of the immigration law that said if a law enforcement officer stops somebody for, say, speeding or committing some traffic violation, and that law enforcement officer then develops a reasonable suspicion that that person is here illegally, that law enforcement officer may detain that person for purposes of calling ICE or calling the federal government to have that person picked up and then deported. That was the part that got upheld. There was another part of our law that got struck down. That was the part that requires illegal aliens to carry their immigration papers. Arizona implemented a very similar law. The Supreme Court said that was preempted by federal law and that Arizona cannot implement that law. Therefore, we can't implement that law, so we will lose on that if we were to appeal further, because the Supreme Court's already ruled on that. And then there was a third component of the law that basically says it's illegal to harbor yourself if you're an illegal alien, or to harbor an illegal alien. That was not directly addressed by the U.S. Supreme Court. The part about the law enforcement detaining illegal aliens, we are going forward with that. We are actually going to ask the Federal Court of Appeals, Fourth Circuit Court of Appeals, to lift the stay that our federal district judge put on us, and we're going to have them lift that so that part of the law can go into effect. That is happening right now. We have already filed that, and we are waiting on a response from the court. So we're going to have that part lifted. We're going to push forward on the part of the law that makes it illegal or criminal to harbor or be harbored if you're an illegal alien. So we are actually going forward with that part. On the other component, that component has been decided by the U.S. Supreme Court. That is outside of my ability to affect. One interesting thing about the stopping of a law enforcement officer having the ability to stop and detain someone, the argument that the government gives us is that the federal government should be able to set its own priorities because they lack resources. They don't have the ability to pick up every single person that gets stopped for speeding. They have drug dealers and people from South America coming up here. They're more focused on those folks. That's fine. The thing is that in our law, it just says the law enforcement officer must contact the federal law enforcement agency. It doesn't say that federal law enforcement agency has to come down and get the detained illegal alien. So that's a farce. That's a bad argument to say that we're putting our priorities on the federal government. Also, the Supreme Court says federal law cannot, or state law cannot preempt federal law. We're not preempting federal law. It's the Obama administration's priorities that are allegedly being preempted. So they're applying a different standard. So it doesn't apply here. One other interesting point, and I always thought this was interesting, if you go to the Department of State website and you look under the Bureau of Consular Affairs, it's a section in the government that basically puts out a manual. It's called the Access Notification Manual. Basically what it does is it promulgates or puts out regulations that tells all local, state, and federal law enforcement officers when you detain someone whom you believe to be an illegal alien, you are to make that determination. You are to ask them the questions, make a determination so that you can advise them of their rights to go to their consulate so that they can get adequate representation. The Justice Department is saying to law enforcement officer, when you stop them, you cannot make that determination for purposes of deporting. So you've got one federal government agency, the Department of Justice, saying, we don't want you to ask the questions for purposes of deporting them. You got the State Department saying, we want you to ask those questions when you stop them, Mr. Law Enforcement Officer, for purposes of getting them to their bureau consulate so they can get protected. So you can see you've got two different standards in the federal government here, and I don't like that. So that's why I'm happy that the Supreme Court has upheld that function. It is consistent now, and as soon as we get the stay lifted, we'll be able to implement that part of the immigration law. I don't know how long it's going to take. I imagine before the end of the year, we should have an answer from the Court of Appeals as to the other part of our law. The main part of our law on immigration has been upheld by the U.S. Supreme Court, and that is something I am happy about. Let's see, what are we going to go to next? We'll do Obamacare next. Let's go ahead and go to voter ID. Voter ID is something that you hear a lot about in the news and the media, and I scratch my head because it's absolutely ridiculous that in a society that we live in, I'm going to talk first about the public policy side, then I'll go into the law. But you have to have a photo identification to board an airplane. You have to have a photo identification to vote in a union election. You have to have a photo identification to go to a federal building to talk to your Social Security administrator. You have to have a photo ID to buy Sudafed, to get prescription medication. These aren't even protected rights in our Constitution. These are just things that we do every day. But something as sacred as a vote and the electoral process by which we elect our officials at the local, state, and federal level is looked at as subservient to something as mundane as buying Sudafed. And South Carolina and other states like South Carolina went and passed a law in 2009, or attempted to pass a law in 2009. It was actually signed a year ago this past May, and we immediately went to pre-clear it. Now, a little background on why we had to do that. In 1965, the Johnson administration passed what was called the Voting Rights Act. Okay, and basically what it said is it recognized that there are certain ethnic and racial groups, minority groups that have been disenfranchised and their rights to vote have been suppressed. And so they looked at several states with a history, and they basically put us in timeout, okay? Now, no one disputes that that happened during that time and that there needed to be corrective measures. No one's going to dispute that. But what happened is under Section 5 of the Voting Rights Act, you have all these states who, and by the way, they're using a formula that's almost 50 years old to determine who should be under the Section 5 coverage. In other words, what state should be on the timeout map. They're using a 45, 50-year-old model. They haven't updated that. So they just reauthorized this in 2006 under the Bush administration for 25 more years. For 25 more years, South Carolina has to go to the federal government to get pre-cleared anytime they want to pass a law that in any way affects an election. In other words, if your local election office wants to change its hours of operation Monday through Friday from 8 to 5, from 8:30 to 5:30, it has to be pre-cleared by the federal government. Something as mundane as that. We have to go ask permission, and we're one of I think 16 states that falls under the pre-clearance list. Now, what I don't like about that is that basically punishes people who have never been born. They basically said in 2006 the kids that haven't even been born are having a 50-year-old standard applied to them. That South Carolina, a third of our federal delegation is minority. We have an Indian female governor. South Carolina has come a long way since 1965. Regardless of what your politics are or how you view things, I think we can all agree that we have turned a corner. We got a long way to go, but we've come a long way. But they still implement Section 5 to treat South Carolina and other states like us like a toddler in timeout. And I'm vehemently against the implementation of Section 5 that's been abused from its original intent. There's another section of the Voting Rights Act called Section 2, which basically just makes it illegal. Section 5 puts us in pre-clearance, meaning we have to get permission to pass a law that affects elections. Section 2 says it's illegal to it's illegal for anyone to be disenfranchised. Anyone based on race or color or ethnicity, you can't be disenfranchised. Since 2009, when the current president took over in his administration, how many Section 2 cases have been brought and actually prosecuted? 0. They always go to Section 5. They always go to the section that basically they use it as a weapon against the states. And I'm not trying to impute an intent to the president or the administration. That's just a fact. You look at Texas, Florida, South Carolina, Virginia, other states that have to go and ask permission. They are retaliating against us. And I'm going to give you some information that's going to shock you. But let's go back to the photo ID law. South Carolina passed its law, and we base it on other laws that have been passed. Indiana, who does not have to, by the way, go get pre-cleared by the federal government. They're one of the northern states that didn't have that history in the 60s, so they can just pass a law and it goes into effect. But the administration, the Justice Department, challenged them on that. In 2007, it was actually during the previous administration, but they were sued by, I believe it was the ACLU and the League of Women Voters, because they said that this was discriminatory because it was going to suppress votes of minorities in Indiana. The United States Supreme Court upheld that law, which is nearly identical to South Carolina's law. In 2007 and in 2006, Georgia passed a law and it was implemented in 2007 that's nearly identical to South Carolina. They're like us. They are under Section 5. They have to get pre-cleared. That was challenged in the court, and at no point during that litigation could they find one single person who would have been harmed by the law. I'm going to give you some statistics in a minute that are going to be interesting. But what you basically have is you have the Supreme Court of the United States upholding the protections of the law that the Justice Department has denied the citizens of South Carolina, contrary to the wishes of the Supreme Court, to the precedent issued by the Supreme Court. Georgia has a similar law. They've gotten it pre-cleared. They got it pre-cleared in 2007. It was challenged in federal court, and even after it was pre-cleared by the federal government at that time, it still passed the court's muster. Now the thing is, our laws, I think, are better, and I'm going to tell you why in a minute. There are a lot of rumors you hear. You hear rumors that, or allegations that there's a poll tax that's going to cost people who are poor, who are sick, infirmed, who are minorities, who live in rural areas. They don't have the ability to get a photo identification. They will not be able to vote because they're poor, sick, or whatever. One thing that a lot of people don't understand about our photo ID law is that if you show up to vote and you don't have a photo ID, you can still vote. No one mentions that. We have what's called the reasonable impediment affidavit provision of the law. If you show up and you say, my name is Alan Wilson, I am 95 years old, I have kidney failure, I was born in a barn by a midwife and never got a birth certificate, whatever sob story you hear, and it may be a legitimate one, you can still vote that day. You can go in and sign what's called a reasonable impediment affidavit that says, I'm Alan Wilson, this is why I couldn't vote, and why I couldn't get a photo ID, but I still want to vote. But what you have just done is you have signed an affidavit under pain of perjury. And that gets filed, okay? It gets filed with the ballot as it's dropped, and then you leave. Now, a lot of the voter fraud that happens, and you hear this from the people who are opponents of voter ID law, you say, well, this is a solution in search of a problem. There is no voter fraud. Well, first off, if you don't give the state the ability and the tools to stop it or catch it, then how can you document it? Because if I walk in to try to vote under Adam Piper's name using his car without a photo ID, if I walk in and vote for Adam Piper and then walk out, how do you go back in time and prove that Alan Wilson voted for Adam Piper? You can't go back and prove a negative. The fraud has happened. If you stop me and you say, hey, Adam Piper's my neighbor, you're not Adam Piper, you have stopped me from voting and then I leave, but it's not documented. So if you stop the person, it's not documented, and if they make it through, you can't go back and prove it. This affidavit, and if you have a religious reason for why you can't get a photograph, that exception is carved out for you too. By the way, they said it's a poll tax. They liken it to a poll tax. The IDs for anyone over the age of 17, the price for a photo ID for people over the age of 17 is free. I mean, it doesn't cost the individual anything. If you're, I think, ages 5 to 16, it costs a whopping $5. Okay, but you're not voting in those age brackets. You only vote at 17 if you'll be 18 by the general election. So the photo ID is free. By the way, this imposes absolutely no new requirements for registering to vote. You still have to register to vote. And if you already have that little green fuzzy card that a lot of us have probably lost, but if you've maintained it in your purse or your wallet, it's probably almost completely worn away because it's mine, I can barely read anymore. It's been in my wallet for years. But if you take that voter registration card down to the voting office, they'll affix your photo to it and then eventually send you a new photograph. They'll take your picture and slap it on there. So if you go in, if you are, say, an African American and you already registered to vote, and you want to go get, and you don't have a driver's license, and you don't have a military ID, and you don't have a passport or a state ID, but you do have a voter registration card, you can go to your voter registration office. If you don't have a reasonable impediment, you can have them slap an ID, a photo on there. You have to do nothing else. Nothing else. There's no new requirement added. It seems very commonsensical to a lot of folks. People say, well, there's no voter fraud going on anywhere. The New York Daily Post did an article back in 2004 where they found that there were 46,000 people who were registered both in the state of New York and in the state of Florida. And they had found at least 400 to 1,000 people in the previous 4 election cycles that had voted in an election. Now, if you go back a couple of election cycles from 2004, you have what's called the 2000 presidential race. How many votes was that state won by? What, 400, 500 votes? But you had 46,000 people that were double registered in 2 states. And in any election in there was 400 to 1,000 people who had voted twice, once in Florida and once in New York. Now, I'm not saying that that would have affected the presidential race. What I'm using that as to illustrate is that some elections, even big elections, have very narrow margins. When you look, go back a couple of years ago, the mayor of Florence won. You remember what the mayor of Florence won by? 1 vote. A mayoral race was won by 1 vote. I was talking to a young woman who was monitoring the 2010 elections. And I remember this vividly because the way she told the story was kind of funny. She was like, I was there visiting some friends, bringing them biscuits and coffee, some of the poll workers, and this gentleman walked in. He was very well dressed and he was very good looking. And she goes, I remember like checking him out because I thought he was good looking. This girl was telling me this. And so she remembered what he looked like. 3 or 4 hours later, she's across town. This is, by the way, this is in Florence County. She's across town taking lunch to people. Some of her friends are poll watching in another precinct across town. The same gentleman walks in. the one that she had seen vote that morning. He walks in, she's like, oh, he must be visiting a friend or bringing lunch. He went in, presented an ID, and voted, and then left. Now, you know, how do you prove that? How do you go back and catch that guy? I mean, and it's an awkward place to be when you're a citizen and you have no reason, you're not going to go over and just challenge somebody. She felt very awkward, but she witnessed this happen. Now, this wasn't the mayoral race that was won by one vote, but you can see how the integrity of the voting system, of our electoral system, it is paramount that whether or not you agree with, whether or not you personally agree with who won an election, you need to believe that that person won fair and square. Otherwise, our government doesn't have legitimacy. And when you look at a race like that, it can be won by one vote, and she saw that one guy walk in, that could have been that previous race. How do you know? You can't prove a negative. In 1984, the U.S. District Attorney in Chicago discovered that there were 80,000 illegal aliens that had been registered to vote. In 1984, a Brooklyn grand jury had discovered that there were thousands of people who were voting illegally because of either they had dual voting, they were voting in multiple jurisdictions or states, or they were illegal aliens. This grand jury, by the way, came up with this. The district attorney that was working there was a former Democratic congresswoman. So it wasn't a partisan issue. But they determined from 68 to 82, for 14 years, that people had been voting illegally in those Brooklyn precincts. So and so when you talk about and I could give you dozens of other types of stories, horror stories, but the thing that you need to take away from this is that you don't need to prove that there is voter fraud to want to have to implement processes that protect the integrity of the voting system. This is not about looking for an ailment to cure. This is about having people trust the election system. Y'all, you want to see the YouTube video where the 26-year-old kid walks in to the Washington, D.C. precinct and says, do you have an Eric Holder on your list? Mm-hmm. And she says, yes, we do. Here you go, Mr. Holder. He says, well, I'd rather show you my ID. Like, you don't need to show us your ID. He says, well, I feel better, so I'll be back as fast as you can say Fast and Furious. And he walks out. He never said he was Eric Holder. He just said, do you have an Eric Holder? So you had a 26-year-old white kid posing as a 60-year-old African-American gentleman who'd been voting in that precinct for several decades. So even the vote of the U.S. Attorney General can be stolen if somebody wanted to. And that was just a humorous example. I wouldn't say it was humorous, it was sad that could happen. When you look at Georgia, now I don't have a lot of the data for South Carolina yet, but when you look at Georgia, they say there are lots of people who are registered to vote but don't have photo ID. In fact, I think our state election commission put out data, state election commission put out data, said there were 230 some odd thousand people who were registered to vote but did not have a photo ID. Then we went and did an audit. The DMV did an audit, and they found out that of that 200 and some thousand people, 90,000 were people who had left the state of South Carolina, surrendered their driver's license in another state, and that state had then sent back a driver's license saying, keep this driver's license, they belong to us now. So to drop that by 90,000. There were, I think, 30, Adam, what was the number? There were 30 some, how many thousands of people that were deceased? But still, there were nearly 30,000 people who were deceased, but names were still, the vital statistics and Social Security Administration had not caught up with taking their names off the voting rolls. So there were like nearly 30,000 people who were dead but still registered to vote. Of that 30 some odd thousand, there were about 950 who were recorded as having voted in an election after they were dead. Now, I'm not saying that actually happened because they did an audit of 200 of those votes. They were able to explain about 80% of the votes as a scrivener's error, a mismark, or a poll worker mistake. And that can be. Then there were some they were not able to determine. They were not able to prove that a deceased individual's identity was used. They were not able to prove that it was used. But you just can't prove it. It was inconclusive. But we've only looked at, and SLED's only looked at about 200 of the 900. And of course, it's very difficult to go back that far and look at it. But those are questions that can be answered at this time. That doesn't prove or negate the need for voter ID laws. That proves the need to reform our system on how we track people in the voter rolls. And we need to go to the General Assembly, and we need to go ahead and reform that because it is antiquated and outdated. But that number from 230,000 got dwindled down to about 27,000 once you accounted for all the people that were in jail and were using the post office box where the detention center was. When you count for, there was a woman who was 130 years old, who still in the voter rolls, And someone joked once that she's been on the Smucker's jar a couple times. But there were lots of irregularities with the list. That was not a literal number. When you look at Georgia, in 2006, right before they passed their voter ID law, 0.05% of the voting age population of the registered voters in the state did not have a photo ID. 0.05%. In 2011, 5 years after their voter ID laws were passed, it was 0.009%. In 2008, they did a national survey of 50,000 registered voters. They found, I think, about 14 people who were unable to get a photo ID, who were registered to have a photo. There were 14 people who were adversely affected. Now remember, in this state, they can still vote with the affidavit. So the data doesn't make sense for the people who are against photo ID. When you look at minority and Hispanic and Caucasian voter participation, let's go to Georgia, because that's our sister state who went through the same process, and we have a much more voter-friendly law than they did. If you look, the law was passed in 2007, and it was in effect in 2008. If you look at 2004, in 2004, the minority turnout was 42% higher than this election before. In 2008, or the voting age minority population was 42%. In 2008, it was 44%. Well, folks said, well, that's because that was the year that President Obama was on the ballot. There was a lot of excitement. That, you know, let's go to 2006, 2010. It went up from 40. It went up to 44%, 2% higher than before in a midterm off-election year. Hispanic vote, Latino and Hispanic went up 160%, 160%. And Caucasian votes in 2004 went up 8%, in 2008 went up 11%. So everybody across the board went up. In Indiana, the election cycle after Indiana passed their voter law, minority participation in the voting process went up over 4 percentage points. So this idea that it's somehow suppressing minority votes is bunk. It's not real. It's a red herring. There's an old saying. If anyone here ever practiced law, if you have good facts, pound the law when you're in court. If you have good law, pound the facts. If you have good facts, pound the law. Or excuse me, if you have bad facts, pound the law. Bad law, pound the facts. And if they're both bad, pound the desk. Scream, rant, rave. Maybe you'll get some attention. Well, that's what's going on here. People are just screaming and ranting and raving, and it's really sad. We have filed for pre-clearance. The Justice Department waited till the eve of Christmas Eve to deny us, to the very last day. We've been now litigating to a 3-judge circuit court in D.C. That is actually going to be going on the last week of August. I will be at that court. It's the same week as the Republican National Convention, so I'm going to miss most of the Republican National Convention because I'm going to be in Washington, D.C. I'm going to be splitting time between Tampa and D.C. But that's when that's going on. So we should hopefully, I'm hoping to have this thing, my goal is to have this heard and have an answer from the court before this next election cycle. Again, Supreme Court upheld it in Indiana, the court upheld it in Georgia, and it was pre-cleared by the previous administration. So that's where we are on voter ID. We talked about immigration. I'm going to touch on Obamacare, and we'll go straight to the grand jury talk. People ask me, how do you feel about the Obamacare, the Affordable Care Act ruling? Very, very, very disappointed in it. I did not see, Kennedy was the one that everyone was talking about. And if you read the dissent, Kennedy and Alito, Scalia, and Thomas were absolutely brilliant. Anybody that agreed with the majority opinion, if you agree with the majority opinion, you read the dissent, you should be ashamed of yourself, because the dissent just ripped the majority completely. They used logic all the way through. There were several functions, or several areas of the Health Care Act that were contested. Now, I'm going to do this real quick. There was the Anti-Injunction Act, which we had to hear on the first day of the Supreme Court argument, which basically says, if this is a tax, then you can't contest a tax until you pay it. And so, remember the administration, when Congress was passing the health care law, they went to great extremes to say, this is not a tax, this is not a tax, this is a penalty, this is a penalty, it's not a tax on the people. And then when they did that because they did not have the political courage or fortitude to face the American people and say, we're raising taxes on people who make less than $250,000 a year. Then they went to court, and the government argued, Well, it's a tax. We have the ability to tax under the Article 1, Section 8, Clause 1 of the Constitution. And if you look at the U.S. Constitution, it is one of enumerated powers for Congress, for the federal government. The framers of our Constitution said that we are not an unlimited government of unlimited powers. We're going to list in there the things that we want Congress to be able to do, and everything that we don't list under the 9th and 10th Amendment, we're going to reserve to the states. So it is specifically enumerated. The government made the argument that under the Commerce Clause, they could compel somebody to buy health insurance, otherwise they would have to pay a penalty or tax depending on who you are. I disagree with that, because if you read the Constitution, it says the government has the ability to regulate commerce, not create commerce. If the framers of the Constitution had wanted us, or wanted Congress to have the ability to create commerce, then they would have written it differently. If you look at it, Congress has the power to create armies and provide for navies. They have the power to create toll roads and post offices. They have the power to coin money, which create money, and then regulate it. They have given Congress the power to create things and regulate things. When it came to commerce, it was only the power to regulate. And you can't shove someone into the stream of commerce for the sole purpose of then regulating them. And that's what they were doing here. And so the court agreed with us. The court disagreed with the administration on two things. First off, they disagreed with them on the Anti-Injunction Act. They said, and what was sad with the majority opinion was, they said, for purposes of the Anti-Injunction Act, we're going to say that this is that this is not a tax, so that we can hear the case. For purposes of the Commerce Clause, we're going to say that it is a tax to avoid striking it down. They took two different positions on two different pieces of the law in order to get the conclusion they did. The dissent, Justices Alito, Thomas Scalia, and Kennedy basically said they had to go back. They didn't interpret the law, they rewrote the law. I'd take it one step further. They rewrote the facts. As you know, the Supreme Court's an appellate body. They don't get to choose their facts. They get the facts handed to them. But they had to disagree with the administration, say, no, administration, you were wrong. This is a tax on the American people, and you can pass a tax. Now, had the government said, when they were passing Obamacare, we're going to tax you, I would have said, this is horrible, this is bad, this is a bad law for multiple reasons, but Congress has the ability, and the state legislature has the ability to pass bad laws, but still be constitutional. There are all kind of bad laws that the government has the ability to be a bad government. It's just when it's unconstitutional. Had they called it a tax from the beginning, we would never have brought this lawsuit. When I became Attorney General in January of 2011, within 3 months I was on the executive committee, was leading the fight on this case, and we all agreed that because they were trying to pass this as Commerce Clause authority, this was dead wrong, and that's why we fought it. The court disagreed with the administration that it was a tax, that it wasn't a tax, and they disagreed with the administration that you can do this under the commerce power. The good news, the silver lining in this court case, is that this is the first time since the mid-1930s that the Supreme Court has rolled back the power of Congress under the Commerce Clause. It has been expanding for 70 to 80 years. They could tell you if you grow wheat, they can make you, if you're growing wheat in your backyard, they can tell you to stop. They can make you destroy it. They can make you get rid of it. You know, there was a marijuana case, same thing. This is the first time the court has said, stop, Congress, you don't have this authority under the Constitution. Unfortunately, the precedent now is that if Congress ever wants to compel you to do something by taxing you from here to kingdom come, they can call it a penalty. That way they don't have to get the heat from the American people for taxing them, and then they can run to the court and change their mind and say it's not a tax, it's a penalty now. It's not a penalty, it's a tax. They can just change their mind, and it's proven that the court will buy that. That's what's scary to me. When you look at what's going to happen, also the court struck down the Medicaid expansion. Good, that was good. They struck down commerce, the argument they struck down Medicaid expansion, meaning the states can opt out. But I am very concerned at what unintended consequences are going to happen with the health care law. Right now, under Obamacare, I was actually doing some research recently. There is a thing called an age ban. Based on your age, you pay a certain amount of a premium, and the market currently says that a person in their 60s is going to pay on average 6 times more than someone in their 20s for health insurance, and that's just based on the free market, and that's what the insurance companies go by when determining how to divvy up the premiums to fund the insurance pool. The Obamacare came in and says we're going to cap that. You cannot charge one age group more than 3 times what you charge another age group. So someone in their 20s
it normally pays 6 times less than someone in their 60s. Well, now that's capped at 3 times. So they have cut in half the amount of premiums collected by senior citizens. So that sounds good. And we do need free market reforms that will actually lower the premiums for senior citizens. But what happens? Who absorbs that cost? I mean, insurance companies just don't, they're not in the charity business. What are they going to do? If you lower the premiums for seniors by government mandate, they're going to raise the premiums for kids in their 20s. And what's going to happen is that they're also going to, when they raise the premiums for the kids in their 20s, that's going to shift that age span, how they rate premiums for senior citizens, thereby raising senior citizens' rates. Prices for everyone go up for the premiums. What's a 25-year-old kid going to do? If you look at actuaries and where we're going to be in a couple of years, a 25-year-old is going to pay $7,000 a year for a private health insurance plan. That's the average cost. Under Obamacare, the penalty is $695. That young, healthy 25-year-old is going to say, why do I want to pay $7 grand a year? Just penalize me, tax me. I'll pay $700 a year. Well, the insurance companies say, fine, you have that right. What's going to happen? The insurance companies are now paying 90%, they're getting 90% less revenue. So what are they going to do with the insurance premiums for everyone still left in the pool? They're going to go up for everybody because they have to absorb that cost somewhere. There are no free lunches. Well, then that 25-year-old kid who's now paying $700 a year, he gets older. He gets into his 30s and he does what I do. He's out there acting like he's 25, throwing a football with his buddy, thinking he can still do what a 25-year-old does. And at age 35, he tears his ACL. So what does he do? Oh my goodness! Well, under Obamacare, under the pre-existing exclusion, he says I need to go get a good policy so that I can get my $70,000 ACL surgeries and get my ACL recouped. So what he does is he gets out of the penalty paying phase. He goes to the insurance company. He pays for a $7,000 policy for 6 months for the duration of getting his surgery, and then he drops the policy. So he paid 6 months of premiums, high premiums, for very expensive surgery, and then dropped it. That's like not carrying auto insurance, totaling your car, going to State Farm or Progressive, getting an auto policy to get your car fixed, and then dropping the policy after it's fixed. What happens a third time? The insurance company has to absorb the cost of that somewhere, and everyone's premiums spiral again. And that's already happening. They are actually seeing that happen. So, and then you start looking at and I could spend another hour talking about Medicaid expansion and the fact that they're cutting Medicaid funding, and they say the states are going to have 90% of the bill paid for by the federal government. By the way, where does the federal government get their money? There's not like a separate money tree that I'm aware of. I didn't learn about it in civics class. If anyone heard of it, let me know. But that's where we are. Obamacare is bad. We are left with a legislative fix or an electoral fix. Elections have consequences. We need judges that don't rewrite facts, and we need a president that respects and understands the Constitution. So that's where we are. Recently, we had, I filed a lawsuit with 6 other states it was the mandate that people provide abortifacient services, and if you're pro-life, that offended you. We thought that was a violation of freedom of religion, freedom to express your religion. The court said we didn't have standing, and they put that back down, said a private person entity will have to bring those lawsuits. We'll file an amicus or friend of the court brief in support of whoever does that, and we will continue to beat the war drum on that issue. That is where we are on Obamacare. Now, let's go and talk about, this is my last issue.
Hey, wait a minute. Let me take this off.
Okay.
You want to adjust it if I can. Get into the questions here pretty quickly.
All right.
I'm going to try this thing myself.
I got one more loop.
One more loop.
It's like a dog leash. All right, I'm getting near the end for Q&A, and I know there's a lot of interest in this. First, let me say this: I brought several copies of the grand jury report involving a case that was going on up here that pre-existed me by about a year as Attorney General. Before I go anywhere, I'm going to give a generic historical understanding of why we have the grand jury system we do today and why it functions the way it does. I won't try to go too far, but I think the context is important. And then, to the degree that I can, I will talk about some more specifics. Understand this. I don't mean to offend if I seem evasive. I'm different. My position is different than almost every other elected official in the state. not like a senator or a representative or a governor or anyone else, or even a sheriff. I'm a quasi-judicial entity. There are rules that apply to me that don't apply to other people. So if I don't start walking down a road or seem evasive, it's because if I don't do that, I could be held in criminal contempt by a court. I could actually be prosecuted. It's very serious stuff. So I'm going to start from the beginning. Let's go back about 1,000 years. Where does the grand jury come from? First off, the grand jury it goes back to Old English times, probably in the first millennium, going into the second millennium, probably around 1100. The grand jury was originally instituted by the king as a way to go out and witch hunt the noblemen and the peasants and the people that were subjects of the crown. To go out there and send magistrates around and round people up and accuse them of worshiping the devil or stealing some guy's horse or something if he didn't like the nobleman. But it eventually evolved over several centuries, and it became a shield or a buffer between the subjects of the crown and the crown. In other words, the crown can no longer say, I don't like you because you won't let me use your serfs for this war I'm doing over here as soldiers, so I'm going to go ahead and bring charges up to you that you're, speaking bad about God or something. The grand jury system was created that it became an accusatory body of peers of the individual, that before the crown could bring a charge, it had to go to this grand jury, these people, and say, this is why we think this person's guilty, and it can't be just because I said so. And so the grand jury would then say, yes, we think the crown has a legitimate case. We're not saying you're guilty, we're just saying we think they have a legitimate case. This isn't just him pointing you out of a crowd. So the grand jury evolved into an accusatory body and an adjudicatory body. And over the centuries, it evolved. The grand jury's powers have waned and expanded with different governments in different centuries, depending on the times. But in modern times, it has evolved to the current state now. What the grand jury is, there are several ways. And remember, the whole purpose of the grand jury originally was to shield the people from their government, from unlawful prosecution and detention. There are several ways the state, that's me or your solicitor, and if you want to refer to us as the crown, that's kind of what they do in Washington now, the mentality is the same. What prevents us from just coming in and kicking in your doors and dragging you out and prosecuting you is the grand jury and our system of criminal justice and jurisprudence. In other words, the only way the state can have the ability to prosecute you is for us to have jurisdiction. The only way we can have jurisdiction, there are several ways we can have jurisdiction. You're indicted by a grand jury. You waive presentment of a grand jury. You say, I don't want the grand jury to hear my case. I'm just going to say, throw myself on the mercy of the court. I'm going to waive it, and you sign it. Or you're charged with a big crime, and there's a smaller crime that fits within that crime. It has the same elements minus a few. Like instead of criminal domestic violence of a high and aggravated nature, you could still plead to the lesser included, and the court would have jurisdiction to hear your case and put a penalty on you. That's what gives us jurisdiction. There are several ways that you can get to the indictment phase. First, you commit a crime, and in the act of committing the crime, you're caught. And a warrant is out for you were served a warrant that charges you, and then you can go post bond if a magistrate will hear that. Or if you're not caught committing a crime, but you are accused of committing a crime, you have to go to a neutral and detached magistrate, and we say, we believe Billy Bob robbed the bank because we saw the gun and the ski mask and everything in the trunk of his car, and it's the exact one that was used. Magistrate would say, there's probable cause to believe that Billy Bob might be guilty of committing that crime. So you can go serve him a warrant. We still don't have jurisdiction over Billy Bob. We can just temporarily detain him. Then that warrant gets presented. And there's two kinds of grand juries. There's a county grand jury. There's 46 of them. There's 18 people on that grand jury. 12 of them have to basically agree with the law enforcement officer. And what will happen is, let's say you're arrested. And during the course of that arrest, they believe that you've committed some crime. That's more than just a traffic violation. Let's say they find, the officer doesn't like you, and he says he had, a brick of cocaine in the trunk of his car. Well, and the grand jury is going to be, well, where's this brick of cocaine? He says, well, I lost it. They're like, we're not going to indict him. You're just picking on a guy here. You got to give us something that believes he probably is guilty. And if 12 of 18 people say that this is ridiculous, they kick that thing. That's all that grand jury does. It doesn't investigate, it just asks a couple of questions. But it's to prevent local police officers from just going willy-nilly and signing warrants for people. So it's a little bit of an insulation from you in the state. Then there's the state grand jury. The state grand jury was modeled on the federal system. We passed a law, and I believe it was in 1989. It went into effect in 1990. Curtis, is that right? So we're in our 23rd grand jury now. It lasts a year. The grand jury, just like a local grand jury, and just like a jury of people in a trial, and by the way, real quick, the difference between any grand jury and a jury in a trial, in a grand jury, we're just saying you probably committed a crime, and only 12 of 18 have to say that. When it gets to trial, evidence is presented with very strict rules on what can be presented and how it can be presented. All 12 people on that jury have to say you're guilty beyond a reasonable doubt. So the bar goes up a lot higher than probable cause. And was that me? Okay. So the bar goes up for what we have, how we have to prove it, and the number of people that have to believe it is everybody, 100% of the jurors. So it's different when you get to court. The state grand jury was passed because the federal system had a way to investigate very complex crimes that a regular grand jury did not have the ability to look into, and that local law enforcement did not have the ability to adequately investigate. These crimes could be environmental crimes, now environmental, gang, drug trafficking. You'd have drug traffickers moving through multiple counties. So you have multiple jurisdictional issues there. So you have to have an investigative body that can go and look at multiple counties. You might have computer crimes. People with the internet, the advent of the internet, you can commit a crime in Lexington County and Anderson County just by having somebody at both ends, perpetrating a fraud. The server could be here, the computer you access it from is there. You get the point. There's a public corruption component of the grand jury that allows us to investigate generic public corruption crimes. The grand jury, there are certain people that are allowed to be in the grand jury. First off, let me tell you what the grand jury is not. The grand jury is not a bunch of elite investigators and prosecutors all huddled in a room 30 days a month, focused on one case like you see on TV. It could be 18 people in this room. Everybody in this room, just by eyeball, if you're over the age of 18, you could potentially be a grand juror. And they come from all over the state. They're from all the counties, representing all geographic areas. They come to Columbia 2 days a month. Not 30 days a month, 2 days a month. They stop doing their jobs and their families, and they come and we put them up in a hotel, and they stay in Columbia for 2 days a month, and they hear any number of a dozen cases. We'll use an example, the lieutenant governor's case. The grand jury, that case lasted from August to, I think, around March, like 8 months. People are like, why did it take 8 months, when we all knew what we knew? Well, the grand jury didn't really look at it for 8 months. The investigators went out and gathered information for 8 months, but they had to sit on it for a couple of weeks for the grand jurors to come to town, and then they had to present it. They presented thousands of documents and pages of material to the grand jury. They had 70 some odd witnesses. If you think about it, over 8 months, there's really only 16 days that the grand jury could have physically looked at that one particular case. And they looked at multiple cases during that 16-day period. If you 2 times 8, do the math. So this is USC education for me, right? 18 days, of course, it wasn't even 18 days. It was probably less than that because they heard multiple cases at that time. So those folks got presented that evidence by investigative bodies such as SLED and local sheriff's offices, and the information is collected by investigators, which is given to our prosecutors, and our prosecutors put up all the agents that are investigated, that do the investigation, take all the statements and all the documents, and it's presented to the grand jury, and the grand jury gets to debate that. We are not even allowed to be in the room when the grand jury votes on anything. We're not allowed to watch the grand jury vote. The Attorney General's office, in fact, a couple of years ago, we got our hand got slapped by the Supreme Court when one of the former head prosecutors there had on the business card and the plaque of her, Curtis, you remember this, a chief of the state grand jury, and the court said, no, you're not chief of the state grand jury. The state grand jury is independent, and it was a nuanceical thing. But if you think about it, what branch of government does the grand jury belong in? It's not mentioned in Articles 1, 2, or 3 of the Constitution. It's only mentioned in one place that I'm aware of in our entire U.S. Constitution, and that's the Fifth Amendment, which means that upon presentment or issuance of an indictment before a grand jury, you can't have capital offenses or other crimes and misdemeanors brought against you. I'm paraphrasing it. So it's not even mentioned in one of the 3 articles that defines the legislative, executive, and judicial branches. So it is kind of a fourth branch of government unto itself if you think about it. We cannot make the grand jury do anything. We can only present evidence to a grand jury. 12 of 18 have got to be convinced that a crime probably committed. That is the standard. If you look at the grand jury report, let me hold it real quick, and I'm gonna start getting specific now. By the way, the grand jury report is not always issued. In fact, it is rarely issued. The grand jury chose to issue this report, and we weren't allowed to go in there while they were voting. But we knew that there were some cases of high-profile nature that people care about, and so we, as legal advisors, said, grand jury, if you want to explain to a degree what you did, we know a lot of people are going to have a lot of questions. We asked the grand jury. They could have said no to us, and we would have had to say okay, but we asked them to consider a grand jury report so that we could get as much information as allowed by law. And under Title 14.7.1720. 14.7.1720 is the statute that that says that if we talk about anything that is presented before a grand jury, then any of us that are sworn, we all have to swear an oath. We do it every June. We could be prosecuted. I mean, it is a criminal offense. It carries up to 1 year in jail, a misdemeanor offense. But we could also be held in criminal contempt by the court. But we go in there, the evidence is presented, we ask the grand jury when they voted, we ask for a grand jury report. And I get questions all the time as, what was presented, who went in there. First off, people who talk to the grand jury, witnesses that are summoned, they can talk. The grand jurors and the staff and the prosecutors and the agent, we are sworn, we can't talk. But any witness that goes before the grand jury, they can say whatever they want. I mean, we don't tell them they can't. Curtis, am I saying anything?
That's correct.
And Curtis Pauling is one of my assistant deputy AGs who's actually actively involved in advising the grand jury on a monthly basis. He is one of 3 supervisors, has been practicing law for, 12 years, 11 as a prosecutor. He's been there since, he was there since 2006, 2005, very experienced prosecutor. I brought him with me. He wanted to come with me today, but, the grand jury issued this report. It's a public document now. We had it done one other time since I've been Attorney General, and that was with the Lieutenant Governor. It is posted on our website. We can even, before I sit down, if anybody wants, we bought a couple of copies. We'll leave them all here. And if you want to be able to go to the website, or if you want someone from our office to email it to you, Adam Piper, before the end of the day, will give you our personal contact information with an email, and we will send you the grand jury report, including the title page. May I use your table as a desk? Just a sec. Including the title page, it is 3 pages. So really only 2 pages of grand jury report. The first page gives a brief introduction and a background and summary, and basically it just tells you when the report was initiated. And I think it started with the 21st grand jury back in 2010. As you know, every June we get a new grand jury. So this thing went through 3 grand juries over 18 months. It finally landed with the 23rd grand jury that issued this report. And every grand jury got to hear all of the evidence, the testimony, everything that every investigator that testified before it gave them. And they all got the same information. We had to start back over and make sure each grand jury was brought up to speed. But I highlighted a few things I wanted to highlight for you. I can't go off the 4 corners of this document just because of how serious it is. But there were 18 witnesses who have testified before the body. In addition, during the investigation, SLED agents and investigators from the Anderson County Sheriff's Office have interviewed a great number of other persons, and statements of these additional witnesses have been summarized and made available to the grand jury. So they got statements from an innumerable number of, they didn't tell us how many, but a lot of people. In addition, subpoenas producing over 10,000 pages have been made available for the grand jury's consideration. They claim that they say we have explored every lead and followed all investigative avenues. The grand jury has thoroughly investigated all of the activities and events associated with the buyout severance agreement of the former county administrator and other related relevant matters concerning other members and or employees of Anderson County. That's the middle paragraph. You can go and you can look at this document yourself. When I talked to Rick, I said, when we spoke about a month ago, and I'm going to wrap up and take questions. I said, Rick, I'm y'all's Attorney General. I work for the people of South Carolina. I will do any and everything people of South Carolina ask me to do, but I will not break the law and I will not violate my oath to the Constitution. I will come up here, and I know there was a lot of folks who had a lot of concern and interest in this. I'm reluctant to even go into opining as to what else may be happening, because if I start opining and indicating what may or may not be happening, I can't indicate one way or the other. I can tell you, as far as the grand jury goes, that was the final act of the grand jury as it relates to the issues that I just read to you. Any other matters that you could be reading about in the news, or different matters, I'm careful not to go off the track. That's just because I'm trying to follow the law and the Constitution as it's given to me. But I work for you, and if you feel like that an injustice has been perpetrated, if you feel that that it has what you wanted to happen didn't happen, and you feel like this is a travesty, there are other things that I can do, and I've already started doing it. When you look at all the petition candidates that were thrown off, or the people who had to go get petitioned because of a stupid technicality, they didn't file a paper copy when they filed a digital copy of their economic interest form. My aunt got thrown off the ballot. She was running for clerk of court in Lexington. It affected me too. My own family got thrown off. I mean, but the Supreme Court strictly applied the law. When you look at the lieutenant governor's issue with the ethics problems that happened in that case, when you look at all the things that the governor went through with the House Ethics Committee, you look at all these things, you look at South Carolina's ranked like 45th in most corrupt states, I got a real problem with that. So I looked at what other states are doing, and I'm in the last minute, Rick, so I'm going to start taking questions. I looked at what other states are doing, and then I went and I spoke with some members of the General Assembly. And we're going to start going. I plan to be working with Ann Thayer, who's been great to work with, by the way, always accessible and represents you very well. But what we're going to do is that we want to reform and redo the entire Ethics Act. And there's two components: the administrative component that threw all these people off the ballot, and all the fees and fines and the definitions, they're all whack, for a colloquial phrase. But then there's the enforcement component. And you have the General Assembly that polices itself and their local ethics committees. You've got the ethics commissions that polices everybody else. And then if it rises to a criminal level, it comes to me, or potentially your solicitor. If it comes to your solicitor, they usually kick it to me, because solicitors usually have to recuse themselves from local officials. What I said, why don't we do this? Why don't we look at and create a public integrity unit? Make it more than ethics. It's ethics, public corruption, tax evasion, anything that affects an elected official. And let's have members of the Attorney General's office, the Inspector General's office, the Department of Revenue, the Ethics Commission, the Department of Public Safety, and SLED. Let's allow auditors, support staff, prosecutors, investigators, forensic examiners, all have them be donated by those agencies, have them co-located in a room where they're all communicating. Because right now, the Ethics Commission, if they get a case, they review it up to see if there's a civil infraction, and then they're finished. I have to ask for it if we think there's a criminal, but then we got to start over and re-review everything they've already done. What if this public integrity unit had it from the beginning and took it all the way to fruition? We don't have to duplicate the time and the effort and the money that goes into reviewing that. And then what will happen is that it will be referred to the appropriate agency for disposition. I want to look at either passing a constitutional amendment, or at least working with the General Assembly to give more oversight to how they police themselves. I don't want to police myself, and you don't want me to police myself. You certainly don't want your members of your own General Assembly to police themselves. And I think that this public integrity unit might be a good way to address that. It's a step in the right direction. And we're going to start drafting legislation that completely overhauls and reforms. It needs to be transparent. You need to be able to look in there and see what's going on so that nothing's swept under the rug. And I know that people probably think that happened in the grand jury. I can tell you this, there's not a single grand juror or a single person on my staff that knows anybody that was being targeted. And if they are, they have to be recused. But this public integrity unit, back to that, it needs to be transparent, but it needs to have enough secrecy so that if you're a local council member and you have someone that ran against you and lost, they can just send a letter accusing you of a crime, then that letter is in the front page of your local paper. It's got to be able to go somewhere where it can be vetted to make sure it's not a wild goose chase or a witch hunt. We don't want to tear people apart, because then good people won't want to run for office. So we have to have a balance. That it's foiable, it's transparent, you can know what it's doing, but it's got to have enough cover so that we can review it to determine if there's anything to it. And that way we don't just go out and tar and feather people in a public venue. So that is just some ideas I have on what I can do as running with and proposing legislation to the General Assembly. And I've already offered our office up in that regard to try to make the criminal justice system and how we account for public integrity, public corruption, and ethics with our elected officials and appointed officials. I want to run with that for you until I'm out of office. Anyway, I've talked a long time. There was a lot to talk about, and y'all been very patient.
Thank you. You can tell Alan, you're not a politician, are you? I don't know why in the world I thought that. Okay. I know many of you have questions in regard to this, and of course you've already been given pretty much the ground rules of what he can and what he cannot do. But the burning question that most of us are going to have here is basically, what was the grand jury told to look at? Period. Blanket. Generic. I know.
I can't go off the document, but it's right here. It says,
I'll have a t-shirt done for Alan Wilson too.
the grand jury has thoroughly, let me read this.
Yeah.
I'll read it again. The grand jury has thoroughly investigated all of the activities and events associated with the buyout/severance agreement of the former county administrator and other related relevant matters concerning other members and/or employees of Anderson County. I'm reading that straight from the grand jury report.
No. I read it to the audience when we got it. I read into that, then the only thing you looked at, as mentioned earlier, first thing off was the buyout. The buyout of our administrator, former. And that's why I asked, is that all?
I'll read it a third time if you want me to.
Look at him.
Yes, sir.
Yeah, come on up here. You got a question? Anybody that's got a question, go, if you're able to walk and whatever, make it central, and then that'll cut to the chase here pretty quick. Okay.
I was
Here, go ahead.
I was down at
No,
the
put it up closer.
Supreme Court here, and
They can't hear you over there.
Okay. And I heard what Gene Cole said, and I heard what the other justices said, and basically they said that the FOIA was violated. I think you've got recordings of that.
Yeah, we
So
played.
there's been a clear violation of state law, and which, in my opinion, and based on what the justice to the left, I believe he's from Greenville, said,
Kittredge. Justice Kittredge.
probably, Kiltron. He basically indicated that that would nullify one of the solutions